And what happened?
And the board voted to find that it was, the board first took a vote to determine whether or not it had the authority to put it on the ballot itself, and it voted 4-9 it did not. And then the board took a vote to find it illegal, and it voted 9-4 that it was. Under the charter, under 8.01 subsection 3, the charter directs the board that once it makes that determination, it is to tell the petitioners that the petition has failed. And that is what's happened. And I understand Your Honor's concern, I do. But that doesn't mean that the board gets to decide that I'm going to ignore what the people have voted for in this charter merely because a more fair result is a different process.
So what is the board doing in order to prevent, you said to me, we're now aware of this. This is the first time we've had to address this. The board is aware of this. So what is the board doing? What did they do yesterday, recognizing the fact that this was something that was created, and perhaps everybody had a little say in why this was not successful in terms of the initiative being able to appear on the ballot? Then what happened?
Well, there are two things that the board has proposed to, as a moving forward correction. Obviously, this is not something that we can go back in time, nor is it something to justify an otherwise illegal act being placed on a presidential election ballot, because that, you don't throw out the baby with the bathwater. But in terms of a going forward basis, there are two pieces of proposals that would potentially address this. The first is a piece of proposal by Commissioner Levine-Cotto, which is to impanel a charter review task force to look at this petition process, to potentially ask the citizens of Miami-Dade County, change your process to make it easier to petition your government. And that's option one. Option two is a proposal by Commissioner Diaz, which is to have a formal request from a commissioner for a county attorney opinion at the time of a public hearing that happens under the charter when the petition is submitted, to give a legal opinion as to the sufficiency. Now, that's not going to bind anybody, but what it will stop, or will advise the petitioners at the front end of the issues that would be potentially before it on the back end. And that would be a better way to express a more substantive review of the ballot question.
But you all don't need it. I always find this to be so interesting. You all don't need the voters to do that, obviously. If the commission itself, once it's submitted to the clerk's office, because I would think that every person that is trying to put something, an initiative on the ballot, they're going to want to know what the hurdles are in the front end. So if you all want to say, submit a copy for consideration to the board or the county attorney, and we will review that, go ahead.
Well, Your Honor, and I understand that, but respectfully, I cannot give opinions to members of the public without authorization from my board. I can't do that.
Okay, submit it to the board.
Well, and fine, and that's the process that Commissioner Diaz is requesting that we institute in going forward with this process. It's submitted to the board. It's not part of the charter process, but what it will do is it'll give the petitioners not only the benefit of their own legal counsel, who's responsible for drafting these questions, but the benefit of the board's legal counsel in what they're thinking about the petition process and about the issues with the petition.
So let me ask you to which is really the nuts and bolts of all of this. How can they actually revive this? How can they actually satisfy the concerns that you all have and still be able to have their voice heard in November?
Well, to begin with, whether or not it was correct or incorrect, the November ballot was never available to them because of the time they submitted it on August 2nd. Because of the times in the charter, there is no possibility of November. To talk about whether or not they could have this on the next countywide election, which is August of 2018, is a debate we can have over the coming months.
Explain the first part. Tell me why it was never available to them because they submitted on August 2nd. Because
the charter requires a 30-day period between when the petitions were actually canvassed and when it can go on the ballot and when it's to be placed on the ballot. That's a provision of the charter. And this court, and it's in our brief, but it's in cases like City of Miami Beach versus Herman said, you cannot pre-place things on the ballot before the time period for placing things on the ballot has expired. And so, if it had gone to the supervisor in the proper, if it had gone immediately when they had presented the petition,